Hello and greetings from beautiful Montreal. On behalf of McGill University, it's with great pleasure that I welcome you all to the webinar on constraints on military uses of outer space. What might international law offer? My name is Jakhu. I'm Associate Professor and Acting Director of the Institute of Air and Space Law of McGill University here in Montreal. First of all, I would like to make a formal statement that recognizes the unique and enduring relationship that exists between Indigenous peoples of Canada and their traditional territories in Canada. McGill University is located on land which has long served as a site of meeting and exchange among Indigenous peoples and nations. McGill University honors, recognizes, and represents these nations as their traditional stewards of the land and waters. This statement befits very well with the purpose of this webinar, which is a meeting of people from around the world. All of us are virtually meeting in order to exchange views on a very important matter that relates to international legal regime for ensuring peaceful uses of outer space. The webinar will discuss the prospects for clarifying the existing international law and expanding it, for restraining the militarization and weaponization of outer space. The subject is not only important for experts or the governments, but is important for everybody on planet Earth because outer space offers tremendous benefits to humanity. Without peaceful, safe, and secure space utilization, those benefits might be jeopardized. This is the fourth webinar in a series of webinars that are being jointly organized by the Institute of Air and Space Law and the International Association for the Advancement of Space Safety, IAASS. Since its creation in 1951, the Institute of Air and Space Law has been the world's leading academic institution in the fields of air law and space law. Next year, the Institute will be celebrating 70th years of its rich history dedicated to excellence in graduate legal education, public service, and scholarship. It has produced more than 1,200 graduates from more than 100 countries. During the last 15 years, the Institute has attracted grants and financial sponsorship worth millions of dollars for student fellowships, outreach activities, and advanced research projects. For the last 15 years, the Institute has been involved, for the last 4 decades, the Institute has been involved in pioneering research related to military uses of outer space. In the early 80s, we carried out several studies and organized numerous conferences which were funded by the Canadian Department of Global Affairs. Our current multi-year research projects relate to the drafting of McGill Manual on international law applicable to military uses of outer space, MILAMOS. We will have a special presentation on that project. We have published several papers on this important topic. Our latest publication is a brief op-ed which Stephen Freeland, David Chen, and I co-authored. It appeared last week in The Conversation and the Hill Times. IAASS was established in 2004 in the aftermath of the Shuttle Columbia accident by a group of safety engineers and managers. Mr. Tommaso Sgobba is one of the founders of IAASS, and he currently serves as the executive director of this institution. Tommaso will provide more details about his organization in his welcome remarks. I have known Tommaso for the last 15 years. He's a highly competent space safety professional, a wonderful person to work with and a good friend of mine. Both of our organizations have long-standing, close and fruitful cooperation in the field of space law and space safety. Over the past several years, both institutions have prepared studies on various subjects. As a permanent observer of the United Nations Committee on Peaceful Uses of Outer Space, the IAASS has submitted the results of these studies to the legal subcommittee of COPIUS. We are, in my view, excellent partners, and we enjoy working with each other. I wish you all a productive webinar and hope that you will enjoy this meeting and find it fruitful and an enjoyable experience. Thank you very much for your attention. Over to you, Tommaso.
Thank you very much, Professor Jakhu, for the nice introduction of the long and fruitful cooperation between McGill, IASL, and IAASS, which started, as you mentioned already, in 2006 and is currently continuing with the series of webinars that we are hosting. I am an aerospace engineer, I am not a lawyer, and I would like to spend a few words on the role of military in space programs. Few words about the historical background of today's discussion. Since the beginning of the space era, both the United States and the former Soviet Union developed and implemented programs that were more military in nature than civilian or scientific. The first man to orbit the Earth on April 12, 1961 was a Soviet Air Force Major, Yuri Gagarin. Alan Shepard, who followed immediately afterward, the first American to reach space on a suborbital flight, was a test pilot from Naval War College. Glenn, Armstrong, Aldrin, and more recently, the Chinese taikonaut Zhai Zigang were all from military. Many of current astronauts are from military. Every US branch of service, including the US Coast Guard, has representation in the astronaut corps. The current head of the European Astronaut Center, Astronaut De Win, is from the Belgian Air Force. His predecessor, Tognini, was from the French Air Force. Currently, all Chinese astronauts are from the People Liberation Army Astronaut Corps. Same story for Space System. The Mercury Redstone rocket, which launched Shepard, was a development of the US Army Ballistic Missile Agency based on the German V2. The Space Shuttle technical heritage was in the military studies and developments such as the United States Air Force Dinosaur of the early 60s. The heritage of the current International Space Station can be tracked back to the military program of US and USSR, respectively the Man Orbiting Laboratory, MOL, Never Flown, and Almaz, which flew under the Civilian Salute program cover and had even a cannon on board. Space military programs were a precursor of all satellites application, from imagery to navigation, telecommunication, and meteorology. Finally, although civilian activities are on the rise, military still play a key role in range safety operation and in space situational awareness. In the 60s, through a tacit agreement between Washington and Moscow, the overhead reconnaissance by satellites was accepted as legitimate confidence building and information exchange means between the US and USSR. Other military uses of satellites, for example, communication, detection of nuclear explosion, missile launchings, and weather monitoring, became so routine that by the time 1967, the year when the Outer Space Treaty came into force, which establishes the principle of peaceful use of outer space, military satellites were already an integral and irreplaceable part of the defense system of both the US and USSR. In the 90s, space became an integral component of military planning. The Persian Gulf War Desert Storm of 1991 was later described as the first space war, since it was the first time that the full range of military space assets were used for fighting. The interest of military use of space is strong and will become even stronger as national security and world economy depend more and more on space-based systems. Such a strategic interest spurs debates and policies about assets protection and in turn space superiority and space control. In this respect, the debate is still raging, which started at the time of the Reagan administration, about limiting space militarization to the current balance of application and to forbid the deployment of space-based weapons. Our webinar of today will discuss the status and possible development of legal issues related to militarization and weaponization of space. To lead the discussion, I am very pleased to introduce the moderator of this webinar, Dr. Raju Gopalan. Raji is a distinguished fellow and head of Nuclear and Space Policy Initiative as Observer Foundation in New Delhi, India. She is also the senior Asian defense writer for Diplomat. She authored 4 books on military and security issues and numerous research articles that have been appearing in editing volumes and in peer-reviewed journals. She has been invited to speak at international fora, including the United Nations Caucus in Vienna, Conference on Disarmament in Geneva, UNIDIR, and on at Asian Regional Forum, ARP, and European Union Forum. She was the technical advisor to a new United Nations group of government experts called GGE on prevention of arms race in outer space, PAROS. Over to you, Raji. Thank you.
Thank you so much, Tommaso, and good morning to everyone. Good morning, good afternoon, good evening, everyone, depending wherever you're all joining us from. Irrespective of the time zone issues, so many of you have joined this morning, and including our panelists who has joined us from Australia, where it is 2 in the morning. So I want to thank everyone who has taken the time and effort to be part of this conversation this morning. So today, like Professor Jakhu and Professor Sgobba said, this webinar is part of the IASL-IAASS webinar series, the 4th in the series, looking at constraints on military uses of outer space. What might international law offer? My name is Raju Rajagopalan. I'm a distinguished fellow with the Observer Research Foundation. We are a public policy think tank based in Delhi. So first, I want to thank Professor Jakhu and the Institute of Air and Space Law at McGill University, as well as Dr. Tommaso Sgobba and the International Association for the Advancement of Space Safety for having me here as part of this conversation and to moderate this discussion this morning. Let me also take the opportunity to introduce and thank a couple of other important people who have remained instrumental in today's webinar. We get Ms. Kiran Mohan Vairapalli. Kiran is pursuing LLM thesis program at the Institute of Air and Space Law at McGill University as an RNGC astronaut graduate fellow. He's also a legal officer at the Asian African Legal Consultative Organization, an intergovernmental organization based in Delhi. Thank you for Kiran for all your efforts. Really appreciate it. Next, let me also acknowledge David Chen. David Chen is the Chief Executive Officer, McGill Center for Research in Air and Space Law, and also the managing editor of the McGill Manual on International Law applicable to military uses of outer space. Popularly, we all know it as the MILAMOS. David, really appreciate your help with this webinar. I also want to recognize Mr. Ramaswamy Venugopal from the IAASS, who has been handling the registration of the webinar. In virtual conversation, there are far too many people who are behind the scene helping us out. Thank you for this in this regard. So coming to the theme of the webinar, it's an important one, and we need to take concrete action if we have to ensure continued and sustained use of outer space. Outer space has become an inalienable part of our lives today, whether it is use of GPS for seeking directions, or the expectation of having seamless communication, or your ability to predicting weather. The impact of space increasingly on military and security matters is also noteworthy. Yet, we do not entirely appreciate the challenges that threaten what we take for granted unless urgent measures are brought in to ensure safe, secure, and continued access to outer space. Many of the threats to outer space, especially from military competition that are witnessed today, are not new and have existed in the past. However, the circumstances appear to be quite different, and countries have shown greater inclination and motivation to develop and use these weapons that could threaten the common use of outer space. Given the heightened sense of competition and rivalry among the major space players, even technological developments for peaceful applications, what we call the on-orbit satellite servicing, which is the refueling and repair of satellites, technologies to clean up space junk, all of these developments are also seen with a lot of suspicion. But any disruption of services or destruction of space assets will have a much wider impact than at any point of time in the past. Given the extensive dependence on space for civilian as well as military operations, offensive or defensive use of space will affect not just the security, but the impact will be felt across security, social and economic domains, as well as across continents. Challenges in outer space are growing and they are varied. Despite the rhetoric and the official positions of states, all the key space players today are developing and adding military elements to their space programs. Of course, there is a security rationale to much of these developments, because primarily this is driven by a competition and a fear that inaction is going to leave them unprotected. There is a constant effort, therefore, to stay competitive and to achieve some sort of parity. The second aspect is the accelerating pace of militarization and early trends of weaponization that needs to be addressed. This is a reflection of the increasing number of advanced military space programs in Asia as well as in other regions across the world. It is true that most militaries around the world use space assets for a number of passive military applications, including communications, intelligence gathering. But the trend towards early weaponization in outer space is particularly worrying. This is still a threshold that has not been crossed in its true sense of the term, but the international community has to work together fast if we have to be able to prevent this. Great powers have a bigger responsibility in this regard to develop consensus so that they are able to frame new global norms to address this particular issue. A third set of issues is the growth of counter space capabilities, which has become a bigger challenge in the space security realm, for instance. While space has been part of the intense political competition between the two space superpowers during the Cold War, the use of space was primarily restricted to strategic operations, such as strategic intelligence gathering, nuclear attack early warning, or even execution of arms control agreements. With more countries relying on outer space today, especially for military applications, it is leading to the development of counter space capabilities that would attack this specific reliance on space. It's begun to play out particularly among the 3-4 big players in the space domain, the US, China, and Russia. The return to anti-satellite testing after a gap of 2 decades, along with the growth of other counter space capabilities, is making space a lot more competitive and contested than before. It's also making space a lot more fragile. Not only did the Chinese ASAT test, for instance, create a large debris cloud, but it also gave reason for other countries to demonstrate their own capabilities. The US ASAT test, Operation Burnt Frost in 2008, and the Indian ASAT test, Mission Shakti in March 2019, are instances in this regard. Further, countries like France is developing different space strategy. Japan is pushing for the development of an interceptor capability. And I can think of many more countries that are likely to go down this path. All of these challenges should serve as an important warning and a reminder that we need to work towards developing an effective outer space regime. However, today there is no clear solution in sight. Lack of consensus among the major space players has become a significant hindrance in having meaningful conversation to start with. While the existing global mechanisms, including the Outer Space Treaty of 1967, have been useful to a large extent in managing to keep the sanctity of outer space as a peaceful domain, these mechanisms do have certain gaps and there are ambiguities that need to be addressed. Most of the existing institutions and measures were developed when threats and challenges were significantly different. Therefore, the prevailing measures have certain flaws and we need new rules of the road. We need definitional clarity, for instance. Lack of definitional clarity on terms like what is peaceful use of outer space or how do you define weaponization of space. These have serious consequences and these need to be addressed in a future mechanism. There have been, of course, several recent efforts to address some of these problems, but none of them have reached a final satisfying destination. Some of the recent efforts include the Russia-China sponsored draft treaty on the prevention of the placement of weapons in outer space, popularly called the PPWT, initially proposed in 2008, and there was a revised text that was introduced in 2014. Then you have the EU-initiated International Code of Conduct for Outer Space Activities. You have two GGs, the UN Group of Governmental Efforts, one in 2013 that came about on looking at two CBMs, the Transparency and Confidence Building Measures. The 2018 one looking at PAROS, the Prevention of Arms Race in outer space. But the acrimonious nature of relations between major powers has peaked to such an extent that in the 2018-19 GG on PAROS, they did not even produce a consensus report at the end of the two-week-long sessions on this particular subject. A number of Western countries, led by the US, for instance, believe that non-legal political instruments such as TCBMs are the way to go about, whereas China and Russia, along with another set of countries, believe that their preference for the legally binding measures and that you need something more binding than a political instrument. And finding a middle path between these two perspectives, these two schools, have not been easy. Anyway, to discuss all of these issues, we have a distinguished group of experts joining us this morning. I'll introduce each of them in a bit as her or his turn comes up. First, a few housekeeping announcements. One, please keep your audio on mute unless you're asked to speak. This is to minimize the background noise as well as any echo, and of course to ensure excellent sound quality. Second, on the structure of the webinar this morning, we will have two presentations at the beginning, which will set the tone for our discussions. Each of the presenters will have 15 minutes to make their presentation. This will be followed by an excellent panel who will comment on the presentations as well as look at some broader set of issues related to space weaponization. The panelists will have about 5 minutes to make their opening statements. The panel will later be joined by the two presenters as well. And once we are done with the presentations and the opening statements, there will be first discussion among the panelists, and I, as a chair, have some questions to the panel as well. Then, of course, we move to the second phase of the discussion where we open it to the audience. We look to get your thoughts, questions, comments, and possibly even expand the conversation into a broader perspective. The audience may please use the chat box. There is an icon at the bottom of the screen to ask you questions, and I'll direct them to a particular panelist or to the entire panel. Now, let me invite our first presenter for this morning, Elina, Dr. Elina Morozova. She's head of the International and Legal Service at the Intersputnik International Organization of Space Communications, which is an intergovernmental satellite telecommunication organization headquartered in Moscow, Russia. She has specialized in the field of international space and telecommunication law, and she has continued to focus on issues related to the use of radio frequency spectrum and satellite orbits, operation of geostationary and non-geostationary satellites, provision of access to the satellite capacity and satellite telecommunication services. Elina is associate editor of the core expert of the McGill of the Milanos Project. She also takes part in the work of the expert committee of the CAS Interplanetary Assembly Regional Commonwealth in the field of communications and serves as the director of the board of the International Institute of Space Law. Over to you, Elina. You have 15 minutes.
Dear Rajesh, thank you very much for this kind introduction. First of all, let me thank the McGill Institute of Air and Space Law and the International Association for the Advancement of Space Safety for inviting me to this webinar. It is a great honor for me to be here with you this morning or today or this evening, depending on whether you are. I would like to also greet all our participants. It is such a pleasure to see many colleagues and friends being safe and well and professionally proactive. Regarding our today's talk, I would like to present the Milanos Project. You have already named the full title. It is the Manual on International Law Applicable to Military Uses of Outer Space. And just to set the scene, let me start with saying that there is indeed international law which regulates space activities, which regulates the regime of outer space and celestial bodies, just to make it clear from the very beginning, and that there are constraints which exist in international law today, which must be complied by all space actors. This is the good news, but it sometimes happens that there are different understandings on whether this or that rule is applicable to military space activities. And even if there is an agreement on the applicability, sometimes different understandings exist on what the content of such rule actually is. And this different understanding can lead to some conflicts in space because states can have different understandings of the other states' acts and behavior, or if not conflicts, I would say those unpleasant or inconvenient or uncomfortable situations. And to achieve a common understanding on what international law is today is a very important task. Therefore, it will definitely help to avoid those situations. And for this understanding to be achieved, at least it is very much important that there is a clear and objective articulation of all legal rules that are applicable to military uses of outer space. And this is exactly what the Milanos project is all about. So the mission of this project is to identify and, if you wish, to distill all the international law norms which regulate activities in outer space, of course, with a particular focus on military space activities, and explain those constraints which exist today. But how to achieve this mission? The first step is to open up a discussion which on the topic which for a number of years have been kept in secrecy and was discussed in a half whisper. So it was necessary to address all of these issues which exist today. It is also important to focus on the law which is applicable to space activities involving the military uses of outer space in the times of peace. It is also relevant if we look to the military space activities in a global security context. And finally, as a result, it is a manual which articulates and clarifies all the international law rules which are applicable to this field. So how is this achieved? Of course, it's done by somebody, and it's always people which are the key to every success. And for this project, an international group of experts was gathered. Experts represent different sectors. They are from the military, from the public, civilian, and academic domains. And first of all, it can ensure that diverse expertise and knowledge is contributed to the project. And it is also a kind of a guarantee that the outcome will be relevant to various stakeholders, because, you know, academia is absolutely perfectly aware of what international law is. and what is the spirit, what is the idea of this regulation. Governmental people knows for sure how these or that rules are implemented in practice and what state stands behind any decision, and industry knows for sure which impact those implementation of legal rules have on what they do every day at their business. The participants represent different fields of science. Of course, it's absolutely important to ensure a synergy between different fields of law, which are applicable to military uses of outer space. It is also very much important that the project is supported by technical experts and that all the relevant technical aspects of the actual uses of outer space are duly taken care of. The participants contribute to the project in their individual capacity. It means that they do not deliver an official state position or an official organization's position. It is done for the purpose that the discussions are transparent and open, and that experts are neutral in their statements and discussions. On the other hand, one may ask, what is the purpose of people not representing states to participate in this project? And I would answer that all of us are not people from nowhere. We come from our states, we come from our environment, where the attitude to legitimate behavior have formed for years, and lots of aspects can affect this understanding of law, including historical, traditional, cultural, and so on and so forth. And to be frank, it is also happens very often that our personal opinions are very much similar to those of our states. And the project also provides for a geographical and gender and generational diverse. And with this, and also with this commitment to be unpaid, to avoid any kind of meeting of expectations, the project is supposed to be fair, inclusive, interdisciplinary, and a truly global endeavor. And let's talk a little bit about how the organization of work was handled. So everything starts with drafting of the rule. There are no authors, there are no personal opinions. The draft is assigned to an expert who has expertise and knowledge in the field and know the problem and can properly deliver all the opinions. After the rule is drafted, it is open for comments by all the experts. Absolutely everyone can contribute to making the rule even more relevant and to accurately include all the perspectives. And the rule is revised one more time, and then usually at the in-person meetings this rule were discussed in plenaries, and once again many more thoughts and ideas and views were reflected, and the discussion were tough. And this can continue as until the consensus is achieved, because each rule can only be adopted by a consensus. It means that all the experts do not object that this is the law as it is to date. After the rules are adopted by the plenaries, it is the work of the editorial committee which revise the rules, but it doesn't mean that the editorial committee can change the content or something substantial. It's just only to ensure that rules are coherent and consistent and comprehensive. And even after that, there is another level of review. Each rule is individually peer-reviewed by international independent experts, and the whole manual as a result of this work will also be peer-reviewed. As to the content on the manual and this misleading word rule, in the legal sense, of course, rules of the manuals are not legal rules. They only reflect those legal norms of international law which can be found in the relevant primary sources of international law. It is nothing about experts' views on the law. It is only the reflection of the primary sources as they exist today. And the rule can be delivered in a different ways, because from this big basket of international law norms, appropriate rules must be taken from, and sometimes, and it is the best case, but very rare, when international law provides a very specific legal rule which is applicable to this certain situation, and that this rule is clear. Very good situation, but very rare. More frequently, there are applicable rules, but they are to some extent unclear. And it also can be the case that there is no legal rule that addresses directly the issue under discussion. For this purpose, there is a commentary which accompanies each rule. It can explain application of legal norms which are relevant to the topic under discussion. They describe different understanding, but of course based on the interpretation of international law. And they also provide, if you wish, the legal context, because even if there is a gap in international law, this gap does not exist in a legal vacuum. There is always a legal context. There are always interconnected rules which can somehow shape the choice of the actor. And the structure of each rules looks as you can see on the slide. So once again, it is always the legal basis which is provided to explain which primary sources of international law relates to the subject matter. Elements of the rules are described, and what is also very much important, some ongoing issues and future challenges are also addressed in the commentary. But the rules themselves do not offer any suggestions, even with regard to these challenges and issues, because lawmaking process is something different. The manual would not be neutral if it went to making suggestions. The manual consists of 3 parts. The first one contains definitional rules which are important to make a clear understanding of all the further chapters and parts. Part 2 is of the utmost interest and importance. For instance, it contains the rights and obligations of state and non-state actors, and can be of interest of those who make policy decision, who make decision connected to operations in space, and so on and so forth. And the last part is a very specific reading about what is going on in space in the military context today. It refers to specific military space activities. And for example, you can find there what you have mentioned at the very beginning as rendezvous and proximity operations, which can be done for the good, for the servicing the satellites which are on orbit today. Of course, the very heated discussion of weapons in space, different types of weapons. Another important matter is national technical means of verification. The manual also deals with different type of interference, which are regulated somehow differently. As examples of interference to spectrum-enabled communications, some topics like jamming and spoofing are described. Some exemptions which exist in international law with regard to military activities related to radio installations and their use. And cyber topic is of course very urgent today and is addressed in the manual. So this is just an example. And where are we now today, and what have already been done? This project was started in October 2016, and the main rule drafting and decision making and discussing process was ended in 2020. During this time, we had 8 workshops to build consensus on the content of the manual and 3 electronic plenaries. Between 2017 and 2018, there was a kind of split in the participating institutions. And if you will look at the end of the process, the participant institutions are not the same as they were in the very beginning. It was because the institution had a slightly different approaches to the process, to the outcomes, and it was clear that the progress can be achieved if there is a kind of a split. Still, In March 2021, the manual is expected to be submitted to the publisher, to Springer, and somewhere in summer of 2021, the manual will be available. And as the main target of the manual is spreading the word, soft copies can be downloaded from the websites for free, and the hard copies may be purchased for money. So everybody who is interested in the manual can get access to its soft copy. And finally, what are expected outcomes? What was it done for? I will start with lesser and finish with the greater. So the one of the targets which has already been achieved, actually, it is this open discussion of the topic, which is very much sensitive. And whether this discussion will continue on an appropriate international level between the states, it is of course dependent on the political will. At least there will be something on the table for the continuation of this discussion. Then I can repeat that the manual indicates some ongoing issues and some challenges which will be very topical quite soon, or are on the table as very urgent today. And the international community may wish either to fill in the gaps or make some changes or whatever would be appropriate on an international level. Then it is our understanding that acknowledgement of the existing international law is the very minimum to increase transparency between the relations of states, to correctly understand state conduct and thereby building confidence. Of course, adherence to these rules is what must be achieved. And finally, it is our sincere opinion that such a manual, being the first in its kind, can really contribute to the conduct of space activities, of course, including military space activities, because it is the main focus of the manual, to be conducted in accordance with international rules of law, and that such conduct can not disrupt the other states' conducts, and preferably it should contribute to what we know as space sustainability, safety, and security. And it would be the benefit not of only for us, but to the generation to come. And with that, I thank you for your attention to this presentation and look forward to our discussion.
Thank you, Dr. Elina. This was such a comprehensive presentation, a very detailed preview of the MILAMOS project. I think it's very valuable to those of us who are outside of the project and looking forward to the final outcome when it is published early next year. I'm sure there'll be a lot of questions and clarifications that might come your way, but I think we will take that up, take those set of questions after the second presentation. It gives me great pleasure now to invite our second presenter for this morning, Ambassador Paul Meyer. Ambassador Paul Meyer is Fellow in International Security and Adjunct Professor of International Studies at Simon Fraser University and a founding member of the Outer Space Institute. Prior to his assuming his current position in 2011, Mr. Meyer had a 35-year career with the Canadian Foreign Service, including his serving as Canada's ambassador to the United Nations and to the Conference on Disarmament in Geneva between 2003-2007. He teaches a course on diplomacy at SFU's School for International Studies and writes on issues of nuclear non-proliferation and disarmament, outer space security, and international cybersecurity. So over to you, Ambassador.
Yes, well, thank you, Raji, and let me, of course, extend my appreciation to the organizers of this webinar. It's important that we have a platform to discuss these sorts of issues, particularly at this point in time. Again, my name is Paul Meyer, and my intention today is to speak to a possibility when we look forward to what international law might have, and that is an optional protocol to the Outer Space Treaty as a legal option to enshrine non-weaponization. Now, as a career diplomat in a previous life with a professional focus on arms control and disarmament policy, there was an aspect of global attitudes towards security in outer space that really puzzled me. And in brief, this was the contrast between, on one hand, a clearly expressed wish to preserve outer space for peaceful use, including its non-weaponization. And on the other hand, a lack of purposeful action by states to achieve this goal. The aspiration has been affirmed via a resolution of the UN General Assembly, which has been adopted annually since 1981 with wide support. For example, in the most recent vote in November of 2020, the resolution was adopted with was adopted in the first committee of the General Assembly with 174 yes votes, only 2 null votes, and null abstentions. And this PEROS resolution, and of course PEROS is the acronym for prevention of an arms race in outer space, specifies the preclusion objective, quote, including the weaponization of outer space, should be the goal of, quote, further measures. The resolution also importantly recognizes, and I quote again, that the legal regime applicable to outer space by itself does not guarantee the prevention of an arms race in outer space, and that there is a need, quote, to consolidate and reinforce the regime and enhance its effectiveness. So the legal regime being referred to here is the 1967 Outer Space Treaty, which in my mind is one of the great and perhaps underappreciated achievements of multilateral diplomacy in the 20th century. This foundational treaty imparted a special status to outer space as a form of global commons beyond any, quote, national appropriation or claim of sovereignty. It specified that the exploration and use of outer space should be for peaceful purposes and, quote, for the benefit and interests of all countries. The Pacific orientation of the treaty was further manifested in its prohibition on putting into orbit nuclear weapons or any other weapon of mass destruction, and its comprehensive ban on the militarization of the moon or any other celestial body. The treaty's prohibition on placement of weapons in space was limited, however, to weapons of mass destruction. And hence, it's not surprising that those supportive of the Pacific aims of the Outer Space Treaty would see the need to extend that ban to all forms of weaponry. This would seem a logical way of giving legal expression to the intent regularly affirmed in the political declaration of the PEROS resolution. High-level expression of support for this action was voiced by the then Canadian Prime Minister, Paul Martin, in his September 2004 address to the UN General Assembly. He stated in that address, and I quote again, "What a tragedy it would be if space became one big weapons arsenal and the scene of a new arms race." In 1967, the United Nations agreed that weapons of mass destruction must not be based in space. The time has come to extend this ban to all weapons. End of citation. 4 years after Prime Minister Martin made his appeal, China and Russia presented to the Conference on Disarmament their proposal for a treaty to accomplish the aim of the non-weaponization of outer space. This treaty on the prevention of the placement of weapons in outer space and of the threat or use of force against space objects, fortunately it's better known by its acronym PPWT, has received something of a chilly reception in the CD. The United States in particular has criticized it for definitional deficiencies, for lack of verification provisions, and its failure to cover ground-to-space weapons. The sponsors of the draft have provided a rebuttal to some of this criticism, but the Conference on Disarmament has not provided a forum conducive for further discussion of the PPWT, as it has been in a state of general gridlock for over 20 years. And China and Russia have so far not been prepared to take their treaty proposal elsewhere. In my opinion, a simpler vehicle could be used to give legal expression to the non-weaponization goal, namely an optional protocol to the Outer Space Treaty. An optional protocol is a legal instrument that supplements an existing international treaty. As the word optional indicates, the protocol does not automatically bind the states parties of the original treaty, but must be separately agreed to by the states concerned. Optional protocols have been widely used in international human rights law. For example, the optional protocol on children in armed conflict from the year 2000, which was an optional protocol to the underlying Convention on the Rights of the Child. Optional protocols have also featured in international disarmament field. For example, the 5 protocols of the 1980 Convention on Certain Conventional Weapons, the CCW. One of the advantages of this approach is that it provides a supplementary agreement to the widely supported Outer Space Treaty, which currently has 110 states parties. That is clearly aligned with the Pacific orientation of the treaty and extends its existing weapons prohibition. The adoption of an optional protocol to the Outer Space Treaty would not entail opening up the Outer Space Treaty itself, which could prompt undesirable amendments to the treaty. The negotiating process for an optional protocol could also be undertaken utilizing existing UN machinery, either through the Committee on the Peaceful Uses of Outer Space, or if consensus agreement was not possible in that body, and it is a body that works on consensus, via a UN General Assembly mandated process. General Assembly works on majority voting basis for its decision making, or even by means of an ad hoc diplomatic conference. If kept simple, an optional protocol that extended the Outer Space Treaty's ban on WMD to all forms of weaponry should not be overly complicated to draft. An objection to this approach could revolve around the question of defining a space weapon, as has been raised in the past with respect to the PPWT, for instance. In my view, there could be 2 ways of responding to such a definitional challenge. 1, offer up a definition, or 2, don't attempt to define the term. If the latter option seems odd to you, I refer you to such Central Arms Control and Disarmament agreements as the Nuclear Non-Proliferation Treaty, the NPT, or the Comprehensive Test Ban Treaty, the CTBT. You will search in vain for a definition of a nuclear weapon in the NPT or of a nuclear explosion in the CTBT. And yet both of these treaties enjoy wide support and high standing. I believe, however, that a suitable definition of weapon could be developed that would be adequate in the eyes of most negotiators. Indeed, the PPWT already offers one, which reads in part, and I quote, any outer space object or component thereof which has been produced or converted to destroy, damage, or disrupt the normal functioning of objects in outer space. It continues that this is, I think, the critical part of it. I don't doubt that such a definition could be improved upon, but it would seem to offer a reasonable basis for a future negotiation. Verification could also be raised as a problem for the envisaged optional protocol, as it was for the PBWT. In my mind, current verification capabilities are adequate to provide confidence the violations of the optional protocol could be detected. Both in the state and in the private sector, we have witnessed great strides in the capabilities of monitoring technologies for space activities. And these could be drawn on to verify compliance with a ban on weapon placement in outer space. The fact that a recent accusation by one leading power about a space object launched by a rival power and its subsequent suspicious actions clearly relied on information derived from so-called national technical means available to the accusing party. This suggests that the barriers to accepting a verification regime for space arms control are more political than they are technical. A further objection to the proposed optional protocol, again, as was raised against the PPWT, was that it fails to cover ground-to-space weapons, in particular terrestrial-based anti-satellite weapons, ASATs. Two approaches to this issue again suggest themselves. The first, ignore this category of weapon and focus only on weapons placed in space. Or, secondly, extend the ban on space weapons to cover ground-to-space systems as well. The former option could be embraced as representing an important step towards codifying the non-weaponization of space norm, and one that would be easier to negotiate than one attempting to cover ground-to-space systems in addition to space-based ones. A salient problem that would be faced in trying to cover ground-to-space systems is that it would have to apply to existing ground and sea-based ballistic missile interceptors that possess an inherent ASAT capability. As the United States has consistently rejected including ballistic missile defense systems in strategic arms reduction negotiations, bringing them on board to a negotiation that would likely be premised on the elimination of these weapon systems appears a diplomatic bridge too far at present. Developments relating to threats to space operations might lead to some reevaluation of this situation, but when one adds the potential of terrestrial-based cyber, laser, and directed energy type weapons, the negotiating challenges begin to seem rather daunting. That said, I think options that cover all or some of the terrestrial-based systems should be explored as well, perhaps at a second stage when some mutual trust has been established after successful observation of an initial optional protocol limited to space-based weapons. A diplomatic maxim is, don't let the best be the enemy of the good. And I believe that saying is relevant to this question of what might be desirable as an initial output or outcome of negotiations. Despite the many different and challenging diplomatic and strategic considerations underlying space security policy, at the core of this issue is a question of political will. Namely, are the 180 plus states which routinely endorse the Paris resolution's call for further measures to prevent the weaponization of outer space prepared to follow through from this position and conclude a legally binding instrument to that end, or are they not? If they are willing, and I think the mounting counter-space threats and growth in space assets that Raji referred to earlier provide compelling motives to do so. An optional protocol to the Outer Space Treaty might afford an attractive means of achieving a non-weaponized status for outer space. I thank you for your attention.
Thank you, Paul. I think this was, again, a very, very interesting presentation, very useful to look at. We need to look at the global governance of outer space in an innovative fashion, because otherwise the kind of stalemate that we have seen in the key negotiating body, which is the Conference on Disarmament in Geneva, is seriously problematic. CD has not negotiated any meaningful, has not had any meaningful discussions or even debates for more than 2 decades. The last one being done at the CD was 1996 with the CTBT. So that tells you the kind of state of the affairs when it comes to the global governance and debates on space security debates. So at this point, I think we have had 2 substantial presentations. Let's take any questions that we may have for the 2 presenters before we move to the panel discussion. So I think we do have a couple of questions. I have my own question as well. So the first question comes to you for Dr. Morozova. Thank you for the presentation. How can technical experts join in this project? Also, how can I integrate space law with radio regulation? From presentation, harmful interference is one of the challenges used in space war. You can think about this particular response to this. In the meanwhile, I wanted to throw out a quick question to Ambassador Paul Meyer. Optional protocol is, of course, one of the possibly easier ways to kind of get around the question of the global governance. But the key question is also, is the world ready for it? And how easy is it to get around to developing a protocol in terms, because like you said, I think you have clearly outlined, it's a political will that is at the core of the issue that we see today. The disagreement not because the countries do not understand the challenges or possible pathways to address them, but the main issue has been in terms of the lack of political will, which resulted in this lack of consensus. So do you think the world is ready for working out, or at least start having those discussions on an optional protocol, where to see the prospects in realistic terms, in a sense? So I'll start with you and then come to Elina.
Yes, thanks, Raji. I mean, I think you're right. Clearly, there is requirement for some leadership here. But I would suggest to you that in this current context, the stakeholders for ensuring space is preserved for peaceful purposes is increasing and intensifying all the time. And at a point where some traditional leading space powers are engaged in disputes, sometimes of a somewhat juvenile nature, it appears, amongst themselves, I think it really calls upon the so-called middle powers, to our states parties to the Outer Space Treaty, to come forward and start showing some leadership and initiating action in order to, say, sustain space for the future. There's a requirement for some adult supervision of this situation that can impair global interests to an enormous degree. And I'm counting on that element. But I should also add that I think civil society and the private sector need and are showing some signs of increasingly getting engaged in this circumstances. Obviously, debris causing ASATs can ruin the business model for all commercial operators of space assets. And so I think that the private sector needs also to articulate more forcefully its concerns about irresponsible state behavior in outer space, and lobby their respective governments to take remedial action to prevent that. There are precedents in diplomacy for this kind of initiative. I can elaborate on those if we want to later, but it has been done in the past. I believe there's strong motivations and reasons for doing so now and in the future.
Thank you. Elina, would you want to comment on the first question?
The first one was about technical expertise, how it can be introduced to the project. So first, I have to say that the major work has already been done. So the draft rule development has already been settled. But what we do and how this expertise can be relevant is peer reviewing. And I would ask Kieran, who kindly assisted this webinar, to share the email of the Milanos project, whether this person can send his bio or some other information, and it can be used for peer reviewing those rules and their elements, because we at the Milamos, we have technical experts, and any outside expertise will be highly appreciated. So please, Kieran, share email, and we will provide feedback and would be happy to receive your thoughts on that. Regarding harmful interference and how it can be relevant to military space activities, space law, and what is actually can happen in space, from the regime of International Telecommunication Union, jamming and spoofing and all other similar acts are regarded harmful interference, which is prohibited. The only thing that it is really not important whether this kind of interference is caused intentionally or unintentionally. For all types of harmful interference, there is a general prohibition. So jamming and spoofing would be prohibited, absolutely prohibited by the ITU, with one exception, which I mentioned on this slide. This exception is granted to military radio installations by the ITU constitution. But first, we have to understand that this exemption is granted to military only. It cannot be understood as a broad notion of governmental needs, safety, security, or other governmental interests. Only military radio installation are granted this exemption. If this not the case for that situation of harmful interference, which is jamming or spoofing, there is the procedure which have to be followed by those suffering this interference, how to achieve its elimination. And there is a process. More so, if, for instance, an issue cannot be settled in this way, there are also provision of general international law which can be applied, and if there is internationally wrongful act, there are also certain consequences, legal consequences, which can occur. So it depends on the situation, but this can illustrate how all these fields or in different branches of international law are interrelated.
Thank you, Elina. I think there are a few more questions. Let's take them, take 2 or 3 questions together and then try and get some response for the 2 of them. One of the first questions is, while weaponization of space is indeed dangerous, the question talks about how militarization is something that has already happened. How should we differentiate between militarization and weaponization? How can state parties be persuaded to improve international space law given the increasing rivalry and competition that go in terms of vertical sophistication of technologies and horizontal in terms of the number of actors? What could be valid arguments to be used? This is to Ambassador Paul Meyer. A total ban of weaponization of space should be an integral part of preserving the status quo regarding military capabilities of leading states, or requires a de-escalation of tension among them. What course of action do you believe? But there is another interesting thought about the fact that you brought out NPT and CTBT, and NPT is success. The question says is really debatable whether it has been successful or not, and the fact that CTBT didn't even enter into force despite several ratifications. So how do you see them as possible models, for instance, the definitional aspects when you come to it? So I think that's a sentiment that is coming across a number of different questions. A third set of questions is, given that every satellite is a kinetic weapon as evidenced by the Iridium Cosmos impact, and there is no obligation to avoid the impact according to Roscosmos and Iridium, how do you see weapons ban working with a sky full of kinetic weapons, so to say, in that sense? So let's take these 3 questions about Paul.
Yeah, let me first say about the NPT and CTBT reference. These are widely supported international security accords, and I was just using them as an example of at times where definition has not been pursued, but there's a common term that is broadly understood, and the fact that there are 4 states still outside the NPT that possess nuclear weapons, or the fact that the CTBT hasn't formally entered into force, I think are not relevant to the point I was making. On militarization of space, yes, as we've noted, the peaceful purposes orientation of the Aerospace Treaty has been interpreted through state practice essentially to mean non-aggressive military use. So military use hasn't been, in a sense, tacitly acquiesced in. And I think we can recognize that there also are, military uses that have beneficial general consequences. I give you, for an example, the surveillance satellites, which can be used to monitor and verify arms control agreements, for instance. And there are perfectly legitimate monitoring and communication uses by the militaries around the world. And I think that will continue. But I do think there's a significant red line between military uses and weaponization of outer space. And clearly that entails deliberate development of capabilities that have as their purpose the destruction or damage or disruption of other space objects. So I do think we can differentiate between the two, and I've been a long believer that it is in the general security interests and well-being interests of our world that we do not cross that red line and engage and weaponize this unique environment.
I think we have an excellent panel also who might want to chip in on some of these questions. Can I start with you, Stephen, Professor Freeland?
Absolutely. Hello, everybody. It's a pleasure to be here. Thank you also to the organizers, and what wonderful presentations from both Elina and Paul. I'm not making excuses, but it's 3:15 in the morning where I am, so if I'm not at my sparkling best, please forgive me. Wonderful presentations. Let me just make a few preliminary comments.
Stephen,
yeah.
If you want to just respond to a couple of questions that came up here, or otherwise we can just move into. But I think we might just want to finish one question for Elina that came up here. So would you want to respond to any of these questions? So one is, of course, the whole question about weaponization and militarization and how do we essentially, yeah. Thank you.
Well, thank you, Raji, and I'll come back and make some comments when you call on me shortly. I mean, of course, that's a vexed question. Clearly, we all understand that, notwithstanding the context of the Outer Space Treaty, notwithstanding some of the things that are in there, that space has been used for military purposes almost from the beginning, for terrestrial military purposes. The technologies that have been developed that you and I use every day in our lives were developed with the goal initially of promoting the strategic and military capabilities of certain countries. So we can't deny, notwithstanding the fact that it pains us sometimes, that space has been, in a sense, militarized in the sense that it is used for military activities. But that's a completely different issue from the issue that now is being discussed about space itself being a warfighting domain, space itself therefore requiring weapons to be placed in space, space itself being an area where there will be a theatre of conflict utilizing weapons. That's a completely different issue. And I think, and I'll come back and make some comments about this when I'm asked for my statement, that ignores the unique the uniqueness of space as an environment, as a physical environment, as a political environment, and as an environment for the future of humanity, and the context in which the legal frameworks that we already have were put into place. Of course, we need initiatives to add to that, and the initiatives about MILAMOS, of which I'm a co-editor, so I won't comment about it any further, and the initiative that Paul is outlining, both are extremely interesting, important initiatives that will help us. But there's already a lot to say about the fact that placing weapons in space, weaponizing space, thinking about space as this area for conflict and a military domain, there's a lot to already that says that essentially goes contrary to the system that we already have. But clearly, as everybody has said, political will is the important thing here. And so to the extent we can make it clearer and make it more stark in terms of what is permissible and what is not, that will help us. But we must keep that divide between the fact that, unfortunately, but realistically, space is used for military purposes already, but that's very different from saying we must weaponize space as a promotion of that. Thanks, Raji.
Thank you, Stephen. Absolutely terrific. Tommaso, do you want to make any comments to any of the questions that we have had so far? If we have any inputs on those, you could respond to them.
No, thanks.
Okay. Professor Ram, do you want to make any comments at this stage to any of the questions that have come up?
No, thanks. I have my comments. Okay. I'll make a little later.
Okay. Okay, great. Okay, so I think we will just take the two last questions before we move into the panel. I think we have an exciting panel, so a lot of the conversations are going to continue forward. But Elina, there's a specific question for you. Commercial and private actors are major driving forces in formulating legislations concerning commercialization and militarization of outer space. Is it possible to achieve a balance between interest and sustainable use of outer space? Can regulatory laws stifle innovation? That is something for you to think about. There is another question for Ambassador Paul. Why the PAROS can't work, and why are we looking at an optional protocol? What are the kind of issues around the PAROS is the question. So if we can get these two questions, responses to these two questions, and then we move on to the panel. Ambassador Paul?
Well, maybe I'll just refer to the last one on PAROS, and as I try to make clear in my presentation, you have a very clear expression of the will of the vast majority of the UN member states in that PAROS resolution adopted on an annual basis over the last now 30 years plus. So we have, I think, this declaratory policy that is crystal clear. And yet, as I noted, there is a contrast when you look at, well, what have states actually done to implement the aims that they applaud and support in that resolution? You referred earlier, Raji, there's been really less than a handful of actual diplomatic initiatives to that and I think that is unfortunate, and I don't want to impugn the sincerity of the member states that support that PAROS resolution each year, but I do stress that the context that we are facing currently is a disturbing one and a threatening one. And I think if we needed further motivation to try to take preventive action, and I've long been a believer in conflict prevention as where you should put your investment rather than having to mop up the detritus of conflict afterwards, it's time now for initiatives to try to deal with this looming threat.
Thank you. Elina, do you want to make any comments?
I can see on the chat, it was a private question. That's why you cannot see it. It came from Mike Maloney. And the question related to situations which are clearly or might be clearly a violation of the Outer Space Treaty. And the question is, what would be the path for adjudication? With your permission, I also will comment on, because it was a private question. So I would say that in international law, we have quite a number of rules about peaceful settlement of disputes, and each of these paths which is available to states can be taken. And of course, I briefly refer to what I have previously said about internationally wrongful acts and legal consequences. If there is an international wrongful act, if it can be proved by an injured state, for instance, we know pretty sure which will be the legal consequences. So there is more difficulty in identifying an international wrongful act than in applying legal consequences of such act, I think. And regarding the question which you have read, I cannot see it on the chat. Maybe it was also a private message. As far as I understand, it was a kind of a question related to somehow an interest of civil and business society in making space sustainable, and whether it is only the state's task for that. And my answer would be that the very physics of space is its nature and character. As we share the same area in what we know the outer space, it cannot be the issue of only 2 or 3 or a couple of states. And I think that other states which cannot be named so far, spacefaring, are very much engaged in all these discussions, because they know for sure that every act which is taken in outer space and every consequence of such an act will irreversibly affect them as well. And I can remind you about the history of liability convention. It were exactly those states which were not at those days spacefaring which moved this legal initiative forward and were very much active in negotiation of this international treaty which somehow bound spacefaring states. And regarding commercial space actors, there is lots of dependence of economies or society on space, and sometimes the private space sectors just share the same satellites which are served the military, and that's why the industry is also very much involved in this dialogue. At least they should be involved as those who can contribute with their vision. I hope I answered this question.
Thank you, Elina. Now, I think we will move to the second phase of this webinar, which is to bring in the 3 panelists we have. Of course, Elina and Paul, who have made the presentation, they will also be part of it. First, let me invite the 3 panelists to make their opening statements. We have Professor Jakhu, who's Associate Professor and Acting Director, Institute of Air and Space Law, McGill University. He's the Project Director of the MILAMOS Project. He has served as the first director of the Masters of Space Studies program of the International Space University. We have a second panelist. Again, he was already heard, Mr. Tommaso Sgobba, who's the Executive Director of the International Association for the Advancement of Space Safety, IAASS. Until 2013, Sgobba was the flight safety at the European Space Agency, including human-rated systems, spacecraft re-entries, space debris, use of nuclear power sources, and planetary protection. Third, and our final panelist for this morning's discussion is Professor Stephen Freeland. He is Professor of International Law at Western Sydney University, specializing in commercial space law, and previously the Dean of the School of Law. He also holds visiting and/or adjunct positions at various other universities and institutes in Copenhagen, Vienna, Toulouse, Hong Kong, Montreal, Kuala Lumpur, London, and Queensland. Prior to becoming an academic, he had a 20-year career as an international commercial lawyer and as an investment banker. He has a very impressive CV. Let me just come to some of them. It's more pertinent one to in this context. He has represented the Australian government at the Committee on the Peaceful Use of Outer Space, the UN COPUS meeting, and has also been appointed by the UN COPUS to chair multilateral discussions on the exploration, exploitation, and utilization of space resources, which will take place in April 2021. He is a co-principal of specialized space law firm Azimuth Advisory, and is also director of the International Institute of Space Law, and a member of the Space Law Committee of both the International Bar Association and International Law Association. Now, let me invite the panel to make their opening statements. Each of the panelists will have 5 minutes each to make their opening statements. Professor Jakhu, may I start with you, please?
Thank you, Raji. I will not take 5 minutes. I'll just say very quickly, because all the points I want to make, they have been made. I just want to pick up the point, actually simply re-emphasize which Ambassador Meyer has been saying. I think it boils down to one point: lack of political will. I don't see there's a lack of fora, lack of ideas, lack of purposes, lack of logic even. What is missing is in the whole thing is the political will. But the question is how you seek that, how you achieve that. And please forgive me for saying it, but I think I have lost or losing some faith in key powers, I mean states. The leadership is very much at the top in their own kind of bubbles. But to change that, I think where I have faith is the general public. Civil society has to be more concerned about it, be aware of that. And I think this is where you can see some change coming. I think webinar like this, and there, of course, there are hundreds of others, I think they're very important so that at the end, my view is the leaders do not suffer, governments don't suffer, private companies do not suffer, it's the people who suffer. So space is not for the government, space is for the people. We have to rely that it is our future of our generation, children and grandchildren, which is at stake. So the reason why I'm saying is we have empirical data experience in that. We just imagine where the whole idea of climate change was, say, 70 years ago, and we are today. And the governments have been forced, quote unquote, to change their policies. And it depends upon different regions of the world, different countries. You see more awareness of the concern or negative implications of the climate change. I think I may take the example of gender equality, for example. I think that has to come. So my hope or my wish is that civil society or individuals have to be very much concerned about. I am in this business, or I know this is what is. I personally find if people do not take steps today or ask or in a way induce their politicians to change the policy they're following, I think we will be kind of doomed. The humanity can be doomed in the way. The dangers of weaponization, the dangers of thinking of war in space, are really mind-boggling. And it is, I think we all need to be aware of that and think about it and try to persuade our politicians to move forward in that. I see there are mostly vested interests and that will be there. But also the last point I will say, if we see the Ottawa Convention on Anti-Personnel Mines, that brings me to the point. I think that was essentially achieved because of the role the civil society played. So I think that kind of initiative, that kind of pressure is needed in the issue we are addressing. That has to stop. The whole idea of weaponization or use of force, or even having slogans as Stephen mentioned, space is war fighting domain kind of stuff. I think it's too dangerous. Thank you.
Thank you. Thank you, Professor Jakhu. Let me go to our second panelist and Stephen, and then we take the questions. Next to you, Tommaso.
Okay, so let's start from here. We hear a lot of statement about space being congested, contested, and competitive. But we don't hear very much about what space should be. And we believe at the IAASS that space should be safe, sustainable, and shared. Although with the two first point, there is an amount of, let's say, general concurrence. About sharing, there is not so much concurrence. There are talking about superiority, etc., which of course is not very much helpful to ensure the safety and sustainability of the space environment. I have to say that the first time that I read about Milanos Project, I was a little bit confused about the objective, because if the objective of Milanos is about the laws applicable to military during the time of in time of peace, then I don't see very much a discussion on weaponization being at the core of this project. Although I fully support, of course, the objective of let's say, keeping space, outer space, free of weapons. The problem, I believe, is in the fact that the overall framework of safety and sustainability, including civil, commercial, and military, is very weak. And this opened the door to, let's say, certain difficulties or certain risk. Please go to the next slide. Kiran, next slide. Okay, good. So first of all, people may have a little bit of confusion about what is a safety. A safety is generally perceived to be just, with reference to humans. Since the beginning of the space adventure, NASA has been a forerunner. Space safety has been defined as not only the human, but also the environment protection, and also the protection of critical systems. So if you, during your operation, you don't jeopardize the human, but you damage beyond, let's say, recovery, a launch pad, or you crash against another satellite, etc., this is considered also a safety issue. So safety is not only human on board, but includes the environment, includes, therefore, space traffic control, and includes, of course, public safety as an extension of the human concern. Recently, we have added to the issue, general issue of space safety, also that of near-Earth object and space weather. Next slide. I was saying that we have a discussion about military constraint for military during in time of peace, because the framework, the safety and sustainability framework is weak overall. So let's see what the Association for the Advancement of Space Safety, my association, has identified as the key points to make space safe and sustainable. So first one is ensure that citizens of all nations are equally protected from the risk posed by overflying space system and objects during launch and re-entry operation. This statement may seem very obvious, except that the way it is treated nowadays is that basically each country decided what is the acceptable risk for foreign countries, and sometimes they do not even quantify or document either the risk that they will take on foreign countries or the risk that or the methods that they would use to let's say calculate such risk. This is a key point because people believe that rockets just go up straight on. As a matter of fact, rockets climb to space, and by doing this, they overfly other countries. Very often, when launching from South America, the European, or from Cape Canaveral, Kennedy Space Center, US, they overfly Central Africa. Or when launching a capsule to the space station, they overfly Europe. So this is an issue because there is no common rules, there's no common understanding about what makes a launch and re-entry safe for everybody. The second point is that systems should be developed according to common rules about what is safety. This is because with common rules we could have a better understanding about the safety and the risk for, as I said, the international community, and this extends also to ground safety. Perhaps you have seen some picture of crowds gathering in front of Russian rockets before launch. This is something truly unique, and it is also, to a large extent, very dangerous. But this is allowed in Russia, which is not allowed in other places, and we should have a common rule in which cases this is allowed. The third point about how making space safe and sustainable is the prevention of collision or interference with other aerospace systems during launch, on-orbit operation, and re-entry. As a matter of fact, there is no truly international coordination of this aspect. There has been a leading role for a number of years from US, but more crowded space becomes difficult for US to be the sole operator of this space traffic management, let's say, infrastructure. The fourth point is that we need to ensure the protection of the ground, air, and on-orbit environment from chemical, radioactive, and debris contamination related to space operation. Also, this seems to be an obvious, let's say, statement, but truly there is nothing that makes this happening. Canada had an experience about the crash of a Soviet satellites and radioactive contamination. We see every day the problem of space debris. Perhaps we know a bit less about what happens to the upper layers of the atmosphere, which are continuously contaminated by the vaporization of re-entry system. And finally, there is the issue of mutual aid provision. When we read the Space Treaty, we read about, in the Outer Space Treaty and in the other one about astronaut safety, we read about helping each other in case of an emergency. But this help, which is doable in case of orbital problems, because there is already an infrastructure in place to help astronauts in distress, because the same infrastructure is used for other purposes, for other kind of accident or disaster. But when we go establishing bases on the moon and things like this, there is nothing in place, everything has to be built. And if there is no definition of what can be done, then this becomes pure words. So concluding my statement, we are discussing about constraint on the military activity space, but truly we should assume that in time of peace, both military, civil, and commercial activities are performed according to the same rule and are this constraint that, although covered in principle in the Outer Space Treaty and other treaties, in practical terms are not truly implemented. Over to you, Raji.
Thank you, Tommaso, and it's been a fairly detailed presentation. Let's move to Stephen, and then we'll come back for the larger set of questions to the panel itself. Over to you, Stephen.
Thank you, Raji, and thank you everybody for your comments thus far. I've got a few points that I just wanted to make in response to what's been said. I think the first thing that perhaps is overlooked in many discussions is that the Outer Space Treaty, and Paul said it, is a remarkable document. It's probably been undervalued, but it's actually quite powerful. And it has a lot to say that is relevant for our behaviors in space. It has a lot to say, therefore, that's relevant in terms of restrictions on military behavior in space. It's very convenient for those interests that are, if you like, their vested interest is to look at ways in which we can engage in military activities. We can perhaps promote the development of weapons technology in space. It's very convenient for those interests to look at one or two or three words, one sentence or two sentences in this document and ignore the fundamental rules about how we interpret treaties and ignore what this treaty says. And I won't go through it all, but Paul has mentioned already some fundamental principles. But if you look right at the beginning of this treaty, and the Outer Space Treaty was agreed after 10 years of discussion by all of the powers in a desperately tense geopolitical situation, yet they agreed that there was a common interest of all humankind in the progress of the exploration and use of outer space for peaceful purposes. I mean, that is the second preambular paragraph. It's a powerful statement. If you go through the Outer Space Treaty, it has a lot to say. Of course, those who talk about military activities focus on Article 4 and they say, well, it doesn't prohibit this and it doesn't prohibit that, and therefore I can do it, which is one, simplistic and naive, but secondly, not correct in the broader context of this treaty. If you look at so many of those fundamental principles that serve us well, freedom of access, the fact that activities are for the benefit of all countries, the fact that we have this non-appropriation principle. The non-appropriation principle, fundamental principle, is a conflict preventing. So Paul was talking about the prevention of conflict. It's a conflict preventing clause, because as we know in history, when you start appropriating for, let's say, resources or whatever, that leads to conflict. So that's a principle that has a lot to say. Of course, you've got the special status of astronauts. Sure, we've heard that they're military people, but they have a special status. They're envoys of humankind. That says something about how this treaty reflects on activities in space. We've got reference to the United Nations Charter. We've got multiple references to cooperation. We've got references to exclusively peaceful purposes and demilitarization on celestial bodies. We've got a regime of international responsibility. We've got obligations of due regard and consultation. So when you put those things together, if I asked everybody in the audience to draft a statement of claim based purely on the Outer Space Treaty that says that, you know, to outline restrictions on military behavior, you would not just look at one sentence in Article 4 of the Outer Space Treaty and says, well, it limits this, but I can do anything else I want, because that whole context of the treaty is very powerful. That said, I agree with every speaker that there are vagaries. I mean, that's just the nature of the context in which this treaty was agreed. Of course, the two superpowers at the time were not going to agree to limit themselves in absolute terms for everything, because that essentially they were the only two powers that had this capability, and they agreed a compromise that would work for the rest of the world, but not unduly restrict themselves, given that their competitive, their capabilities at the time. And of course, but so there are vagaries in the language, as there are in every treaty. There are points where we don't cover the specific technologies that we have now. And I completely agree, therefore, that any initiative that reinforces the power of this treaty is to be looked at. We need to understand the rules and the interpretation. That's why projects like MILAMOS are so important. We can only move forward once we understand what we have at the present. We need to supplement by various ways. So we've had references to hard law, PPWT type activities. We've had reference to non-binding instruments like the Code of Conduct. Paul's suggestion is an excellent suggestion for supplementing that power and making it even more concrete. Now, some of you might criticize Paul's suggestion by saying, well, it's an optional protocol, and therefore, if you've got 110 states parties to the Outer Space Treaty, it may well be that in the first instance, maybe a dozen, maybe 20, but certainly not all 110 of them will agree to, in a sense, alter the way they view space by signing on also to this protocol. And therefore, the argument might go, you're going to have a fragmentation, and that would be dangerous. Well, in fact, I completely disagree with that as an argument, because history shows us that a notion like an optional protocol works. It's a progressive development of a change of standards. So you see, for example, optional protocol 13 for the European Convention on the Human Rights, which brings into play the prohibition on the death penalty, which of course, as everybody knows, was not included in the European Convention, given the time that it was put together. Ultimately, this optional protocol comes about. First one country, then a number of countries, and now virtually every country that's a party to the European Convention is now a party to that optional protocol. Over time, it has changed the way we think about things. Another really powerful example that hasn't been mentioned, but you're all aware that there has been a prohibition on the use of nuclear weapons, a treaty prohibiting nuclear weapons that has been drafted, that has multiple signatories, that will come into force in January of 2021. And that's an initiative driven largely by civil society, a civil society group called ICANN, which in fact received the Nobel Peace Prize. for its work in doing that. Okay, it's now got in excess of 50 states parties. We all understand that none of the nuclear powers will sign on to it, and indeed have said that this is a bad idea. And of course, that's what we will hear from the nuclear powers, because this is a treaty that purports to limit and restrict their, if you like, technological superiority. But things will happen over time. Civil society, and as Ram says, it's got to work, from all of those voices below the diplomatic level that will work together to gradually bring about these changes. It would be wonderful if everybody agreed on day one, but ultimately it's initiatives in understanding the rules and then building on them with initiatives like the one that Paul's suggesting that will take place. Tommaso mentioned this well-known mantra about space being competitive, congested, and contested. We've seen the rhetoric of space ratchet up quite dramatically over recent decades, and certainly over recent years, that in fact give rise to creeping colonization, give rise to the threats of an arms race, give rise to war in space. In a sense, terrestrial tensions are now being transplanted such that space is regarded as the same. Well, we've got to fight against that, because a lot of that rhetoric, a lot of this contested, congested, competitive rhetoric, a lot of this idea that a war in space is inevitable can, if we're not careful, be self-fulfilling. So as well as competitive, contested, and congested, I offer some other words, Tommaso. Mine begin all with C. Yours all began with S, but space is also cooperative and collaborative and collective and commercial. And we've already had some discussion about the commercial sector. The space commercial sector is $400 billion plus per annum and growing at 10%. And the commercial sector, as Paul and Elina quite rightly said, they would have some significant issues if the warfare mentality of space compromises their ability. So they are one voice amongst a whole series of voices we need to hear to move forward. And so I'm in complete agreement that this will not be easy. There are many vested interests. Sure, space is important for national security. We all understand that. Sure, space is a dual-use domain. We all understand that. But space, there's so much common interest in avoiding the unthinkable. And who will suffer the most if the unthinkable happens? It will be the major spacefaring nations. We will all suffer, of course, because every community, every country is dependent on space. But the major spacefaring nations have the greatest space capability. They've been able to garner space for the greatest advantage. They have the greatest technical capability. They are therefore, to the greatest degree, dependent on space. They are therefore the most vulnerable if we screw up, if we get it wrong, if we take the wrong path and cross those red lines that Paul referred to. And so in the end, we need to recalibrate the language of space and focus on the common interests that we have. Sure, let's be competitive. Sure, let's try to do the best for ourselves. But let's also recognize that there are many common interests, and there's many good people who are working in that regard. And as Ram says, that message needs to be, because that message isn't necessarily a message that comes top down from diplomacy, from the decision makers. It's a message that civil society and others must push up towards it. And I applaud anyone who is trying in that regard. I urge you all to do that. And I fully support initiatives that will help us to move towards a path to assure that space remains safe, secure, and sustainable, not only for our generation, but for future generations. Thank you, Raji. Over to you.
Thank you, Steve. And I think that was an extensive presentation looking at commenting on the presentations themselves, but I think you also broadened the set of discussions. I think what I'm going to do is take a collect a few questions for you first, because I think it's 3:34 in the morning. We would like to relieve as quickly as possible. So I'm going to collect a few questions. There have been a few here already. So one of the first questions is the UN Security Council UNSC Resolution 1540 highlighted by the United States to justify their intervention in Iraq, defined the term weapons of mass destruction. Could we consider amending Article 4 of the OST, Outer Space Treaty, in order to have a more precise definition of this concept? I think that's something that has puzzled a lot of us, whether that's something possible. The prohibition of the militarization of the celestial bodies is clear in the 67 treaty. Could this be the case for other aspects of the international space law? There is one more question here. Do we really need a specific international legal instrument when you consider that the humanitarian norms are part of the customary international law, and they fall also under the OSD Article 3? So would you really need something, a specific international law for this specific purpose, in a sense? And you did touch upon the civil society role in the rulemaking exercise. Where do you see the commercial actors that could play a role in setting guidelines, rules, regulations, or even legal instruments in the future? Stephen, over to you.
Thank you. And of course, I'll defer to my wonderful fellow panelists and Elina and Paul to answer some of these things as well. It's quite correct to say that we don't have a definition of a weapon of mass destruction in the treaty. Clearly, even though the question refers to the specific resolution that talked about weapons of mass destructions in the specific situation of Iraq, albeit that history showed us that the reality was perhaps different, we don't have an absolute understanding of what a weapon of mass destruction might be for the purposes of international space law. I think it's important, therefore, because there is this uncertainty, to look towards broadening our conception of what type of weapons should be prohibited in any event. An object that isn't necessarily a traditional, if I may say, weapon of mass destruction can create and cause massive destruction. And, you know, sometimes we need to understand that, and this is where the danger of being too narrow in the way you read the overall framework of the way we operate in space, by saying, well, you know, it's only referring to chemical and biological and nuclear weapons, but we can do anything else. You know, that's not the way that the treaty framework is put together, albeit that the express limitations are on particular type of weapons. But, you know, I urge people to read the treaty framework, read the Travaux Preparatoires, read all of the General Assembly discussions around the treaties, and look at the context of these treaties, and perhaps we can move forward. In terms of civil society, well, I've already expressed my view, and Ram has as well. Civil society has an incredibly important part to play, as Paul says in this. This is an issue not just for states, because anything that we do in space will impact on all levels of society. Space and the way we utilize space has massive implications for human rights, both the human rights of individuals on Earth, and ultimately we need to think about the human rights of humans in space. So I think civil society has an incredibly important part to play, because it is impacted by, and therefore has a voice in, the way we utilize space. There are many voices we need to look to. The other question related to humanitarian law, the laws of war. And of course, the Geneva Conventions and the additional protocols, which manifest many of the important principles of the law of war, are extremely important. They've served us really, really well. The problem is we can't automatically just transpose these laws, which have been developed for, if you like, terrestrial warfare, transpose it to this unique environment of space without recognizing that there is a unique environment of space, both from a physical viewpoint, but also from a legal viewpoint. The laws of war, international humanitarian law, applies when you have the conflict. So you need, as a prerequisite, an armed conflict before these laws apply. What we're all here trying to do is avoid that armed conflict taking place in space. And so we need to create, and that's why the MILAMOS is so important in looking at the rules before the armed conflict. As Paul said, we don't want to be cleaning up the detritus, and we may not be able to clean up the detritus of a war in space. We need to look at the preventative side. So the international humanitarian laws are important, but if we have to resort to them, it's almost too late in one sense, because we're already at that point of the armed conflict. And what I think is important for all of us in this debate, and I think we're all on the same side here, is to try to come up with ideas, initiatives, rules, understandings that will mean that we never have to go to that point. I know that sounds, some people call me an optimist, but to be honest, I'm a realist, because we have no other choice. If we take the wrong path, then we move on to a level of consequence that becomes unthinkable and irreversible, and ultimately compromises all of our abilities to garner space, and ultimately compromises what space is and how we view it. So I hope that's given some gloss to the questions, but I'll defer to my wonderful friends and colleagues to add. Thank you. I'll take my leave now, if that's okay, everybody. Please forgive me. It is 4 o'clock in the morning, my time, so I think I deserve. But thank you to Paul and Elina for wonderful, wonderful presentations, and Tommaso, Ram, and Raji, thank you, and Kieran and David for everything. And I wish everybody well. My apologies for leaving, but please forgive me. All the best.
Thank you very much, Stephen.
Thank you so much.
Wonderful.
Thank you so much for staying with us.
Bye-bye.
Thank you. Yeah. Bye. So, yeah, we have a lot of questions from the audience, but I also want to throw some of the questions that I had kind of conceptualized earlier based on your presentations. Let me start with Tommaso. So one question that keeps coming up is, you have looked at the space safety issue for a very long time. So which legal constraints would you think on military operations would support space safety and sustainability? Because here, I think much of the conversation is happening on space security developments and what kind of restrictions can come about. What in your view, which are those legal constraints that might actually support space safety and sustainability? If you can answer that, and then we'll go around the panel. Over to you, Tommaso.
Yes, very, very, very good and very interesting question. As I was mentioning before, when we look to military activities in time of peace, we have to concentrate perhaps on two activities in particular. One is anti-satellite test, and the other is testing of ballistic missile. Let's start from the second one. Many countries perform such testing, but there is one country in particular, North Korea, that does this testing, with perhaps some diplomatic intention. And they do this outside their territory. Now, there was in 1963 a first so-called partial test ban treaty that was about nuclear weapons, which established a simple principle. You can do everything you want within your territorial limits, but you shall not either contaminate the atmosphere or outer space or water and any other environment with radioactive debris and things like this, if they are outside your territorial limits. So if we follow the same principle for testing activities during and in time of peace, then North Korea should be able to do their tests, but never coming out in terms of risk for the population outside their territorial limits. And their territorial limits means, of course, latitude, longitude, and also altitude. But the delimitation between outer space and airspace has been left very much undecided for 70 years, 60 years. And this is truly not a matter of technical difficulty. It's purely, as mentioned before by Paul and also by Ram, a matter of political will. There is no political will to establish what is the delimitation between airspace and outer space, because this may be constraining certain activities. And, you can always argue if you are in space or outer space from this point of view. So one of the issues is ICBM. The other is the anti-satellites system. Now, we have seen testing performed by the Chinese that was very much criticized because the testing caused a cloud of debris that will be there for decades and represent a threat and an dramatic increase in the population of space debris. Later on, we have seen India making a test, but a lower altitude, so perhaps less threatening for the space environment. And we have seen apparently a number of tests performed by China, blank tests, so where basically it has been simulated a nascent test. Now, even when these tests are done without endangering the space environment, they clearly are made in preparation of something that could be very dangerous for the space environment. So my point is that as long as a test is done, a weapon test is done, which either is a threat, immediate threat for the environment, atmospheric, orbital, water, whatever, outside the territorial limits of a country, or can do harm in future, in time of war, because you are prepared yourself for this, this should not be allowed. And so we need to reinforce this understanding. There is a lot of important words stated under Article 9 of the Outer Space Treaty. But Article 9 is a little bit dated because it concentrates on threats that were more immediately perceived or understood at the time it was assigned. Today we have new threats. So I believe that the optional instrument that has been proposed could be very useful in supporting a refinement of the understanding of what Article 9 truly is meant to achieve. Back to you, Raji. Thanks.
Okay. Thank you. Thank you for that clarification. I think there's a lot that the audience is also interested. But if I can come to you, Professor Ram, I think when we talk about the MILAMOS and other the broader space weaponization in the debates, one key question is how do you define a space weapon? What is a space weapon? Is there a precise definition, or is there a need for arriving at some sort of an agreement on what a space weapon is? And is it crucial in the context of a disarmament agreement or some sort of an instrument that we might come about in the context of disarmament and arms control? Is it necessary and is it possible, feasible? So where do you think the definitional aspect of a space weapon is and where those debates are? If you could respond to that, Professor Ram?
Yes, thank you, Raji. I think the point has been discussed, and I won't elaborate too much on that. I think Paul has mentioned, and Stephen also. I think it's always better to have clarity of what is being regulated. I think it's important to know what a space weapon is. But my view is that the debate has been going on for decades. What space weapon is. The reason for that is because everybody wants to read from his or her angle and keeping his or her own agenda in mind. I think if one looks at from objective perspective, it's very easy. Weapon is a weapon is a weapon. That means simply looking at what is the ordinary meaning of the term. You pick up any dictionary, you just Google it, it will tell you what weapon is. And that means a kind of an instrument, a device, or a thing which cause harm and also cause damage. Now, if you use that term in the space context, because that we are talking, to me, is a space weapon will be simply a space object which is designed or will be used for causing harm and damage, whether it includes terrestrial based weapons or not. I think these are matter of different matters which could be dealt outside the definition itself. What is prohibited, what is not prohibited. And now the question is, can we reach a consensus on that? Yes. I mean, the world can reach, countries can reach consensus if they want it. I think the question is not whether they can, the question is whether they want it or not. I think to me, I don't think they need, or they don't feel the need for reaching consensus. But I want to come to the point which Stephen mentioned. I think that makes a lot of sense in certain way. Sometimes there's a need for clarity to have definition. Sometimes it is better to keep undefined. Things have not, like Outer Space Treaty or Paul has mentioned Nuclear Proliferation Treaty. I will say 67 Outer Space, the Partial Test Ban Treaty, things work. There was no problem. But if you define, then you freeze that definition. Certain things they evolve period of time. I think weapons of mass destruction have not defined, but I think it's a good idea. Everybody understand that the creation of a big cloud of space debris, to me, is a weapon of mass destruction. It doesn't have to be nuclear, right? So I think that there's no need for that kind of a. But if we do not have definition, that should not be. This is what I would like to emphasize. That should not be barrier in the conclusion of any disarmament agreement, including the additional protocol which Paul is recommending, which I fully subscribe to. I don't think we should be simply hung up this, hey, there's no definition, we can't move. I think there's reason to move forward without a particular definition of a weapon.
Thank you, Professor Ram. I think this would take me to Ambassador Paul with the possible thing. If we are going to be, if it's going to be difficult to define what a space weapon is and come to some sort of an agreement among all the major states, is it important to focus on the behavioral approach as well as the impact of certain actions? Is that a better approach? I think that is something for me to look at. But I also want to bring in Elina here. I want to ask her one of the questions, for again, tied to some of this definition definitional aspects. The MILAMOS, the manual, contains definitional rules and the names of some of the rules which are somewhat theoretical. But how useful are those rules from a practical point of view? Maybe Elina, can start with you if that's okay.
Indeed, in the MILAMOS manual, there are lengthy discussion of the notions, basic notions in international space law, but once again, it is not an academic approach to writing a manuscript. The very essence of this project from the very beginning was to draft the manual, which is very much relevant to practitioners. And with a couple of examples, I can convince you that sometimes from the correct understanding of definition, many legal consequences depends correctly. For instance, for many years, there was a discussion of what a space object is. It's one of those definitions similar to what have been discussed. It is a definition which is not precise. It's like a guidance how to understand what it is, like we have discussed with weapons, whether precise definition is needed or not. And at those days, it was clear to states that they cannot limit this definition of space object of what they knew at the beginning of space era, and the definition was left unclear. But with this exact notion, many rights and obligations of states are related, for instance, registration. And there is little discussion about whether military satellites must be registered. And I would refer to what Tommaso have said about the intention to have similar rules applicable equally to military and non-military activity. And for instance, registration of space object is exactly the case. You must register your satellite, whether it performs military or non-military function. But if we go further to this definition, space object also includes its component parts. And, you know, it's very much sensitive to some modern space assets architecture. I will explain in some more details. Some military architectures provide for launching of a satellite, very important for the support of states' security and defense needs. And let's call it the BOSS satellite. When it is launched in space, from this BOSS satellites, some small sats are separated and they orbit this BOSS satellite. And the desire which is announced is connected to controlling normal operations of these BOSS satellites. And the temptation is not to register these small sats. And if they are not registered and if other states cannot see them from the Earth, these small sats can also serve the purpose of guarding the BOSS satellites. They just orbit like space mines and space bombs. And it was a big surprise at the MILAMOS plenary to have a very tough discussion of what space object is, because depending of the understanding of this notion and its correct application, either the military have to register each piece of metal or whatever which they launch into space, and this is the case. We know lots of cases of dispense payloads separating in space, and each such case must be registered. So I wouldn't say that there is something purely academic in even understanding these notions and concepts.
Thank you, Elina. Paul?
Yeah, I think you pointed to a distinction that can be made. I've often used the metaphor of hardware and software when describing possible approaches to arms control. You can focus on the weapon system itself and trying to define that, etc., and restricting it in some way. Or you can have an effects-based definition that looks at the action and would, for instance, ban action that damaged, destroyed, or disrupted the normal functioning of a space object. And in that, I would also say, I think there's a presumption when you look at the Elder Space Treaty, I think Article 9's reference to avoiding harmful interference. So obviously, harmful interference would also be an action that shouldn't be permitted. So that is an alternative way of progressing. I think all of these matters are say diplomatically feasible. They can be rendered if there's the will to proceed to defining further supplementary constraints on the military use of outer space.
Okay, I think we are nearing 2.5 hours. It's been a fascinating conversations. So I think there are just 1 or 2 more questions, and I think then I'll ask everyone, to all the 4 panelists, to make your closing statements, and then we can wrap up this discussion. One is, there is a little difference between offensive and defensive installations these days. Where does the manual, the MILAMOS, draw a line between the two? This is open to any of the panel. Any of the panel, you can take it up. Second is the question says, I tend to agree with Professor Freeland on optional protocol to OST. Aviation law example with WASA convention system is not encouraging, especially with the Guatemala City protocol. Same is the problem with the nuclear liability regime. With the protocols to both Vienna Convention and Paris Convention suffering similar with the lack of ratification. So if these are some open questions to the panel, and Paul or anybody else, Professor Ram or anybody you want to respond to these. So want to take any of these questions? Otherwise we will.
Let me respond to the issue, if I understand correctly, about offensive weapons or defensive weapons, something like that. I don't think they are offensive weapons or defensive weapons or weapons. The question for what purpose they are used. And I think that is the question. I think the use of weapons, use of force is illegal. There is no doubt about it. In any, in a broader sense, it's a use of force is illegal, except in one case, that is in case of self-defense, individual or collective self-defense under Article 51 of the UN Charter. Now, there are conditions on that you can use it only an armed attack has occurred. And so that is one. So that means you can use weapons which will in defensive respond, if I can use the term. But also use of weapons is also governed by protocols. The humanitarian law. Certain weapons cannot be used, and also how you use that, and the whole question of proportionality. Those things are, even self-defense, use of self-defense is constrained by law. I think this is what Milanos Project is trying to determine: what is allowed, what is not allowed, what conditions is to be fulfilled in that manner. And I think this is, again, if I can beat our own drum in that way, is that the purpose of MILAMOS is really to clarify the law rather than just believing what somebody published in the newspaper or a statement made by politicians or people in that. So that is, I think, it's very important to understand the law as it is, and the source of law may be different, maybe space law, international humanitarian law, telecommunication law. So see exactly what the law is and what it governs. And also, more importantly, I think that is, so what is not covered, that is the gaps are being identified. This is where we see the merit and the main purpose of for this seminar is the bringing in and the expertise, like Paul Meyer, that these gaps can be filled in that. So once you do what the law is, what are the gaps and what should be done? I think that is the whole story. So I have elaborated my response to the question of offensive or defensive weapons. I think should be okay. Yeah.
Thank you. Are there any closing statements that any one of the panelists would like to make? Any final comments? I'll come to you, Tommaso. Just a second.
Yeah, if I might, I felt that Stephen referred to the rhetoric around outer space, and I think it is rather crucial that we focus on the kind of discourse we're engaged in. Words matter, and it's important to articulate what kind of vision we have for outer space. Is it to be a realm of peaceful cooperation amongst states to advance human knowledge and interests, or is it to be a battleground? So in that regard, he recalled, and this came under the U.S. administration of Barack Obama, this description of space as contested, congested, competitive. Yeah, those are aspects, but as Stephen reminded us, it's also a realm for cooperation, collaboration, collective interests, and I would add the common heritage if we're keeping with our alliteration of scenes. So it's important that we recognize those elements. I think, frankly, the Trump administration did a disservice to its own national security as well as global security by embracing the depiction of outer space as, quote, a war-fighting domain. I mean, why would you want to depict it in that way unless you intended to fight a war there? I think this is an area that we need to, in a sense, push back on and have a discourse more in line with what I would suggest is in the interests and values of the vast majority, not only of states, but also of peoples and indeed commercial actors. So I wanted to leave with that thought.
Yeah.
To all together.
Yeah, Raji, I would like to make a very short statement, which is the following. Professor Jakhu started this webinar making reference to the longer cooperation we had between IAASS and McGill University. As a matter of fact, we started this cooperation by establishing a joint working group on the so-called ICAO for space. ICAO, as many of you may know, is the International Civil Aviation Organization in charge of regulating internationally traffic safety, air traffic safety, etc. So after 16 years from that working group, I am still very much concerned about the lack, not so much of a vision, because there is, or there was, a shared vision about space, but the lack of an infrastructure like ICAO that could deal with the variety of problems of space, including interfaces between civil and military space. So this is my concluding remark, and perhaps adding that there has been traditionally concern in the US administration about supranational organization, but ICAO is not a supranational organization, is an international cooperation. So there is no way ICAO can force a country to follow the commonly agreed rules, but it is the interest of the various countries to continue to follow this rule. Thank you very much for this opportunity. Thank you, Raj.
Thank you so much. Elina, do you want to make any final statements, or otherwise I think we are actually now full 2.5 hours, but if you want to make a short comment.
I will make a short comment. It doesn't look like a final statement, but our discussion made me do this comment. There is lots of skepticism whether civil society and industry should involve in this state's monopoly, drafting law or negotiating law, suggesting law, clarifying or whatever. And there are comments on the chat about maybe a naive approach of those who believe in the strengths of civil and business society. And just a small real example to convince you that you even do not know how strong you are. In Intersputnik, we have 26 member states, and some of them are developing, and we cooperate with developing states to help them establish their national space system and launch first satellites. In this cooperation, we refer to a US launcher for this launch, and the one of the requirements was to give confirmation that these satellites will be registered. And our partner said that, sorry, we are not a party to the registration convention. We do not have this international obligation. And it even was not of interest to the US launcher. They didn't ask whether it was an international obligation on the part of that state. A US launcher wanted to behave reasonably, and they just said that it is a requirement. Do you want to have your tickets in space, or you would like to speak about international law? And this is a clear example how industry or civil society can implement or introduce barriers or requirements even stronger that are established in the international level. So I think we do have to do whatever is dependent on us.
Thank you, Elina. Professor Ram, I'm going to hand it back to you. So let me just do I don't think I can do justice to summing up the 2.5-hour discussion, but I just want to highlight some of the critical problems, challenges that we face in this regard. And I think Paul, in his very opening remarks, the presentation did make it very clear. There are several challenges facing the global governance, the rule-making exercise in outer space. But I think the most critical one is the lack of consensus among the major powers and the crisis, the resultant crisis in decision-making process, paralyzing the entire process of developing rules of the road in tune with the contemporary sets of challenges. Paul put it as the lack of political will. Those political impediments have become the most important challenges in a sense. But at the same time, given nature of space security challenges that are still evolving in the for outer space capabilities and other set of issues, there has to be a concerted effort by all states, especially the bigger top players, in coming together and develop rules of the road. It can start with normative behavioral approach, but I think the norms of responsible behavior, that could be the starting point. But if we have to be able to bring in all the major powers and have an inclusive process in developing the rules of the road, which will ensure at the end of the day, ensure better compliance and therefore better enforcement in a sense, it has to involve everybody. It has to involve certain amount of compromise, which also means that you have to look at, in the longer term at least, a legally binding mechanism, a legally binding verifiable mechanism. But you may have to start with somewhat a sort of a political instrument, or some sort of a transparency and confidence building measures, or some sort of a normative exercise. But I think there are also people who talk about legally binding TCBMs. I think so. There are ways to look at these. And of course, you provided, Paul, you provided an excellent option in terms of looking at an optional protocol to the outer space treaty. I think we have to have innovative ways of looking at this particular subject. But clearly, we need rules of the road in this if we have to have continued, safe, sustainable use of outer space for the future generations. Thank you so much, and I really enjoyed moderating this discussion. Back to you, Professor Jakhu.
Thank you very much, Raji. Just a final statement is I just piggyback what Paul mentioned. I fully agree with his final statement. Just to add one thing, on that May this year, another sad thing happened when the executive order from Donald Trump denied that outer space as a global common. US government or international community as a whole has been accepting, applauding, and propagating that outer space is a global common. But that executive order denied that. I think that's a very sad development. And my appeal to everybody in the audience and otherwise, say we should defy that kind of a slogan or the words. I think if we deny that space belongs to one country or group of countries, I think then we are in a big trouble. Space, in my view, is a global common, need to be used and explored for the benefit, the interest of all countries and for future generation. So that is my final statement on that. But the final is I really want to express my deep appreciation, Rajiv, for you first handling and moderating this panel brilliantly. Thank you very much. And of course, the two presentations have been brilliant. And I really appreciate Elina and Paul's efforts and making the presentation clear, precise, and beautifully presented. My good friend has left. I know I always admire Stephen, and I can tell you I admire because I can never survive at 3 o'clock and say some sensible things. But he did a fantastic job at that time. And Tommaso is the person, I said it earlier, I love to work with Tommaso precisely because he's an engineer. That means he knows precisely what to do, how to organize, no left and right, and system approach, and it keeps me away from, or at least he tries, and I say mostly succeed, keeping me away from blah, blah, blah. I think, thank you very much, Tommaso, and our, our assistant and Kiran and David and Ramaswamy have done a wonderful job. And again, this webinar would have been impossible without the participants or attendees. So we appreciate your presence with us. We hope that we have informed you, given you some different perspective, but I will say the debate continues on that. Should you need any information about the MILAMOS project, about the Institute, or for IAASS, and let us know. So we will keep you informed. Our next venture, probably it will happen next year. But again, thank you very much. And we used to say, have a safe flight or safe trip back home. Now we'll say, stay safe. That is the message. Again, thank you very much. It has been a wonderful participating in the webinar.
Thank you. My thanks to the entire panel and the two presenters and Professor Ram and Tommaso. Thanks so much, and for the opportunity to be part of this conversation and moderate this terrific panel. Not to take away the.
Thank you very much again.
Thank you.
All the best.
Thank you.
Thank
Stay
you.
safe.